Today's topic for discussion is tort of negligence. Definition of negligence. The word negligence has been derived from the Latin term negligentia, which means disregard. Tort of negligence is a duty imposed on a person by law to act with care towards others. If this duty exists and there is a failure to act carefully and another suffers loss, then the tort of negligence is committed. According to Winfield and Jolowicz, negligence is the breach of a legal duty to take care which result in damage, undesired by the defendant to the plaintiff. Essential elements of negligence in torts. Duty of care towards plaintiff. Breach of duty. Consequential harm to plaintiff. Types of negligence. There are three types of negligence in general. A. Nonfeasance, which means not doing an act which you had to do. B. Misfeasance, which means do an act wrongfully. C. Malfeasance, which means doing wrong acts. The most important maxim in torts of negligence is, residential ipsa loquitur, which means thing speaks for itself. In the situation of negligence, the burden of proof shifts to the defendant rather than to the plaintiff. Product liability due to negligence of manufacturer. This was established in the case of Donahue v. Stevenson. In this case, the plaintiff's friend brought a bottle of ginger beer for the plaintiff from a shop. The plaintiff fell ill after consuming the ginger beer. It was found that there was a decomposed snail present under the ginger beer's bottle. The plaintiff sued the manufacturer for the harm he suffered, but the manufacturer tried to take the defense by saying that he has not sold the bottle, but it was the shopkeeper from where they have bought that. But the court held that, although there is no relation between the manufacturer and the plaintiff, but the manufacturer has its responsibility till the end consumer. Contributory negligence. Contributory negligence is a legal principle that prohibits victims from recovering compensation in a personal injury claim if they were even 1% responsible for their own injuries. Case related to contributory negligence is Rural Transport Service v. Beslam B.B., 1980. In this case, the plaintiff sat on an overcrowded bus with the order of the conductor. The driver was known to the situation that the bus is overcrowded and some passengers are sitting on the roof of the bus. He negligently drove the bus that led to an accident. Because of that, the plaintiff suffered harm. The court held in this case that both plaintiff and the defendant are at fault. So, it is the case of contributory negligence. Last opportunity rule in law of torts. In simple terms, last opportunity means the opportunity which can be used to prevent the harm and that should be visible that if that act would have been done by that man the harm could have been prevented. Overall, it is a kind of defense which is taken by the defendant to avoid the liability. The landmark case for last opportunity rule in law of torts is Davies v. Mann. In this case, the defendant's servant has left a donkey on the road with tying his legs. There was a motorcar coming from the other side of the road, and that collided with the donkey. Because of the collision, the donkey got killed and the plaintiff suffered harm. The court held that although the plaintiff was at fault, but the defendant had the last opportunity to control his motorcar, so the defendant was held liable in this case.